So we're not in court this week. That's not really true. We've got motions all this week. So most of the stuff this week is going in front of a judge. On non-jury matters, the defense attorneys are basically asking for bench warrant lifts, bond reductions, some sort of bonds. Anyway, that's going on upstairs, but it's all defense attorney motions. So it kind of leads in to what I wanted to talk with you about today. There's a couple of topics that has brought up a lot of interest, and one of those is bonds. I see it all the time where people say, how in the world can this person be out on a bond? We can't really blame any of that on the magistrates if it's a murder bond. Magistrates aren't allowed to set murder bonds. So what happens is a person that goes in on a capital charge, say murder, or even some of the rapes, anything that carries life imprisonment, the magistrate can't set the bond for that. So they do make the defendant aware of their charges, and then that person would make a motion to go in front of a circuit court judge or state judge who sets those bond or denies those bonds. A bond can be anything from, there's different kinds, but the kind that we usually see is what's known as a surety bond. That means that a judge will set an amount and a bondsman will get involved, and the defendant will have to put up no more than 10%, but sometimes as little as 2% of that bond. So take, for example, a magistrate were to set a bond on trafficking cocaine in the amount of $50,000. The most the defendant would have to put up would be about $5,000 or 10%. Most of the time, because there's competition between bonding companies, that bondsman may foot 98% of the bill, and only the defendant would come up with 2% because of supply and demand. We've got a lot of bondsmen around. If that happens, the person will be out on whatever 2% of $50,000 is. A bond is set for two reasons, and we go over, as I say we, the solicitor's office goes to every bond hearing in the unincorporated area, and then like Myrtle Beach or North Myrtle Beach, they would have their own prosecutors going. But we go to those and we basically talk to the judge, the magistrate, about two things. The flight risk part, that's where you're saying stuff like, this person has no ties to Horry County, he is from Bridgeport, Connecticut, and was just here on vacation, or this person's an illegal immigrant with a passport. Those are all things that we would talk about being flight risk. In other words, when their case is called for trial, they're not going to show back up. The second thing that's of importance to the magistrate is the danger to the community part. So if a person has a long criminal history, that would be a danger to the community, not necessarily to himself or to the individual victim, but the community at large. Now, here's where we've had some pretty ugly fights, and the magistrates won't hit you up on this, but the circuit court judges will sometimes say, well, he hasn't been convicted of those things. That is a terrible misreading of the law. What's happening when we're arguing about dangerousness to the community, that is not beyond a reasonable doubt standard. That is not to say, well, he was convicted here, here, and here. There are many times that a person will get in trouble, get out of jail, get rearrested, get out of jail, get rearrested, get out of jail, and we're up there saying, hey, judge, he's got 4 pending charges in our office, and they're 2 months old. Some of the circuit court judges have, the arguments that we've gotten into, they would say, well, you haven't tried him. Well, I can't try somebody in 4 months on 4 different charges, but that's not what we're here about. We're here because every time he gets out, there's another victim in his wake. So, that's our argument. Sometimes we're successful with it. Sometimes the judges don't want to hear it, and heighten the standard to all I want to hear about is the convictions that they've gotten. And obviously, we would want to have those convictions, but you can't get them when, as soon as they get out, they get rearrested. So those are the only 2 things that the judges are looking at when they set a bond. And especially with our area, it can seem sometime with shootings that this guy will get a bond and this guy won't. And, just like with regards to some of the sentencing, which we'll talk about at another sit down, it really relies on whatever judge is there. It relies on what sort of record the person has, and to some extent it relies on your victim. If your victim will not show up or will not be involved at the bond part of it, you're probably not going to get bond denied. If there's a reason for them not to come, we'll certainly explain that. But those are some of the reasons that one person may get a bond or may get a very high bond, and someone else could get a low bond. I talked with you about surety bonds. That's the 10%. There's something that we call a 10% bond, and that bond is where the magistrate will allow you to post 10%. You post it out at the jail on a $50,000 bond, you would leave $5,000 at the magistrate's office. The neat thing about that is that if you do show up to court on your appointed date, regardless of whether or not you're convicted, all that is to do is assure that you show back up. If you are set free at that point, if you show up like you're supposed to and you're set free, they will give you your $5,000 back. If you are convicted, they'll give it to your parents or whoever your next of kin is. But you get that money back. That's not a surety bond, that's a 10% bond. And the one other bond that I wanted to talk with you about today is shorthand called a PR bond or personal recognizance bond, but that's basically a promise. That, in my opinion, should only be used for someone with no record or a very small record. But that's the bond where you're promising to come back. If I don't come back, then you can keep my promise. You're not going to get anything else. Those are the people that never show up. And when they don't show up, then we've got to send the sheriff, we've got to get a bench warrant because they didn't show. Then we've got to get the sheriff's office to go out and arrest those people. And guess who pays for that? That's the taxpayer. You are paying the sheriff to go do what a bondsman would do in all of the surety events. The bondsman is going to be on the hook. So the bondsman, like Dog the Bounty Hunter, the bondsman is going to go out and find them. When they set a PR bond, that's just a promise. And there's no bondsman involved. And on those occasions, the sheriff's office has to go hunt them down. So that's the different bonds. That's a short preview of why there would be bonds set on some things and some not. One thing to keep in mind is if it's CSC with a minor under the age of 11, that carries up to life. Murder carries up to life imprisonment or the death penalty. Some burglaries carry up to life. Anything that carries up to life, a magistrate can't set it. So if you get mad with someone setting a bond on those type charges, that is the circuit court judge. That's not the magistrate. The magistrate sets any other bonds. Basically 99% of the bonds are set by magistrates. All right, I hope that explains some of the bonds stuff, and the next time we'll talk about sentencing ranges.